Hey everyone, so welcome. We're just going to wait a couple moments while we let people filter in to the webinar, and then we'll get started. Okay, so people seem to be filtering in. So hi everybody, and welcome to the webinar on privacy, the surveillance and technology program. Before we get started, I would like to start with some quick housekeeping. So first of all, this is being recorded. Your cameras and sound will remain off the entire session. But you can put your questions in the Q&A section in the below, and we'll try and answer as many as possible at the end. I would like to begin with a land acknowledgement. We recognize that many of us are joining from different places across Canada, and we encourage everyone to take a moment to learn about the Indigenous lands and territories where they are participating from today. That being said, I would like to acknowledge that CCLA's office and the for this event are located in Toronto, which is traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the lands that Indigenous people have lived on and cared for since time immemorial. We are honored to live and work on this land. With that, I would like to hand it over to Tamir Israel and Timilehin to introduce themselves. So Tamir, please take it away.
Thank you, Michael, and thank you everyone for joining us today. My name is Tamir, and I'm the director of the Privacy Surveillance and Technology Program at CCLA. My pronouns are he, him, and I'm joined today by my colleague, Timilehin Oho. Timilehin, did you want to introduce yourself? Yeah.
Oh, yes. It's a pleasure to be speaking to this audience today. And my name is Timilehin Ojo. I'm the privacy coordinator here at CCLA in the privacy surveillance and technology team.
Thank you, Timilehin. So our program focuses on addressing the negative impacts of emerging technologies on our human rights and on the growing ability of various governments and corporate actors to use our personal information in ways that are not necessarily in our interest and could erode core elements of our democracy in ways that tend to fall most heavily on marginalized communities. We're living at a time of rapid technological change where an array of AI tools are automating many elements of our day-to-day lives, our work, and our interactions with the government. These AI technologies are dependent on accessing and processing our personal information in order to make decisions about us, and frequently lead to opaque and unaccountable decision-making. It's more important than ever to safeguard our fundamental right to privacy, and this is what our program attempts to bring about. So today we're going to talk about a few of the projects that we've been working on with the objective of providing a general sense of the type of work we've been doing, which tends to involve a mix of public advocacy, engagement with the legislative process, and participation in the courts. The first project we're going to talk about is an advocacy campaign we've been working on with the aim of ensuring privacy rights during the election process. I'm going to turn it over to my colleague Timilehin to talk a bit about the concerns we're trying to address with this campaign. So over to you, Timilehin.
Thank you, Tamir. Yes, talking about electoral campaigns itself and the electoral process and the kind of challenges that have been faced when it comes to privacy in that space. I would say very quickly that it's not totally new for most of those following the polity so far when it comes to challenges that have been faced in that space. The background is not also just one that has just started today, but has some historical inclination to it. But when we're looking at this, and one of the major actions we've been taking at CCLA that has to do with this concerns the legislative activity and action, specifically around Bill C4 and Bill C25, as we would agree, there's a major gap when it comes to the privacy protection in relation to electoral data in Canada today. And the call that we do make at CCLA is for that gap to be breached by the political parties, basically by the government, to ensure that political parties in Canada are being regulated by Canada's privacy laws. The call to Parliament is basically to establish clear, enforceable privacy rules governing how political parties get to collect, use, and share Canadian personal information when it comes to electioneering. At present, to give background, federal political parties currently operates outside the core privacy laws governing privacy in Canada. Unlike many other institutions such as hospitals, banks, schools, and government agencies generally, political parties are not being governed by the binding privacy laws that are in place in Canada. There definitely are calls for upgrade of those laws, but at the moment, those laws are still not even governing political parties in the first place, which is definitely a concern for us at this time. So it basically means that political parties are able to collect sensitive personal information, including voters' addresses, demographics, issue preferences, amongst others, and gets to use them without any safeguards, legal safeguards in place. This definitely is a concern. And one of the ways that you can point to that as a concern is the latest or recent political party-enabled data breach of Alberta's voters list that impacted close to 3 million Albertarians, which basically underscores the concern on this. CCLA's position and call, together with other civil society organizations, is very, very simple. It's straightforward. First of all, we're asking that binding privacy laws apply to political parties and their agents, which is aligned with Canadian privacy principles. We're also asking that voters are guaranteed meaningful rights to access of their information, correction, deletion, etc. And on the other hand, we're asking for oversight by the Office of the Privacy Commissioner with enforceable authority. And we're also pushing for against legislations that fall short of the minimum standard required for privacy protections in Canada, such as BOC4 and BOC5. This is just an overview of what actions CCL is taking on this particular issue.
Thanks, Timilehin. As part of this campaign, we've been circulating a parliamentary petition that will force the legislature, our federal legislature, to consider applying privacy laws to political parties. And I am going to take a moment to plug this petition and urge you all to visit voterprivacy.ca and sign the petition through there. But I'm going to talk about another project now, and this relates to a court intervention that we've been doing before the Ontario Court of Appeal. And this appeal is grappling with the fact that police now have access to facial recognition technologies, which is an AI tool, and trying to understand how the availability of this technology for law enforcement should impact our constitutional right to privacy. Facial recognition is a technology that lets you identify anyone in a live or historic image by algorithmically matching the person to a known photograph of the person and then getting their name that way. The technology poses a significant threat to our anonymity when it works properly, but it also frequently fails to work properly. It'll identify the wrong person, and when this happens, it can severely upend people's lives. There's a number of people in the US in recent years that have been arrested just on the basis of a problematic and mistaken facial recognition match, which just shows how significant the impact of this can be for people who are just going about their lives. To make matters even worse, facial recognition tends to operate with significant racial bias. So members of marginalized groups are far more likely to be misidentified by facial recognition. Error rates for Indigenous people, for example, can be 50 to 120 times higher than for other people. Now, the privacy implications of this capability are also pretty significant. So normally, police can't ask someone in the street for their identity without having some basis to suspect that they're involved in criminal activity. But in our appeal, police accept that this is a restriction that they're under, that they can't ask people to identify themselves without some basis for thinking that they're involved in criminal activity. But they're arguing that what they can do is take a photograph of someone and then use this facial recognition capabilities that they already have to identify them, and that there's no constitutional restrictions to this activity. Our intervention is arguing that we cannot let the availability of an intrusive technology like facial recognition effectively disrupt our constitutional right to privacy in the way that police are suggesting. So we're going to turn now to a description of some of our legislative advocacy and particularly talk about our work around Bill C-22 as a starting point, which is a new surveillance proposal that's being rapidly pushed through the government, through the parliament. And I'm going to turn over to my colleague Timilehin to outline this proposal and some of the concerns that it raises. And then I'll talk a little bit more about the legislation as well. Timilehin?
Thank you, Tamir. Yes, so talking about Bill C-22, or coming back to legislative activities, that part of the concerns that we would have and we would continue to raise when it comes to CCLA's activities and actions. Bill C-22 is the bill that's been referred to as the Lawful Access Act and was introduced to Parliament within the first reading of the bill being March 12, 2026, that's earlier this year. However, it would be interesting to note that 98 days later, exactly about 3 months and 6 days, that's specifically on June 18, 2026, the bill was passed by the House of Commons and now it's before the Senate for consideration. However, for today, the focus would be majorly around part 2 of the bill. And part of what is important to highlight is the fact that it's correct to say that, or to identify this bill as a modified version of Part 14 and 15 of Bill C-2, Bill C-2 being the Strong Borders Act. This was the bill that was shelved after a lot of public pushback, then reintroduced in modified form as Bill C-22. Now, Bill C-22 basically is divided into 3 parts, and those 3 parts have Part 1, Part 2, Part 3, but Part 3 is not a focus. Part 1 is titled The Timely Access to Data and Information, while Part 2 is titled The Supporting Authorized Access to Information Act. While the focus of today would be on Part 2, it's important to also mention some of the concerns with respect to Part 1 of this bill. Some of the concerns with respect to Part 1 includes the data retention amongst, as well as the cross-border sharing of information or data, amongst other issues. But staying back within the framework of Part 2 of the bill, what's really the focus of the bill as of now is the fact that aside from the speed by which this bill has blazed through Parliament, there are a number of concerns that have far-reaching consequences when it comes to what this bill would allow to be done within Canada. And for CCLA and other civil society, we've been vocal about the dangers of the bill as it currently is. We can look at, first of all, the intrusiveness of the regime that is being proposed in this bill as one of the concerns that would be raised. I would be flagging, just highlighting some of these concerns alone, as Tamir would go into more details about breaking them down. But when we look at concerns, we're talking about the intrusiveness of the regime. We're looking at the cybersecurity risk that it's basically going to introduce. Cybersecurity risks such as the fact that there are certain backdoor access that have been requested, possibility of attack on encryption as some of those concerns when it comes to cybersecurity risk. Then when it's considered also alongside the harm and impact that such kind of legislation or regime could have on specific communities, the implication of the law and the possible impact of the law becomes more real because certain communities are likely going to suffer more than others. Marginalized communities, for example, is one of those kind of concerns. Over surveilled communities are also part of these communities that definitely would have more impact when it comes to this bill. Another concern on the bill, around the bill generally, is the secrecy order, which basically is difficult to manage such a regime. It's basically difficult to put appropriate safeguards in place with respect to such. We have data retention issues and more as part of the concerns of the bill. We would state the fact that Part 2 would generally require companies such as internet and phone providers to building technical capabilities, and such technical capabilities could hand over data that is within their control to the police or to the CSIS on request. And this may be without even any information or knowledge to the individuals concerned. The position of civil society, CCLA specifically on the bill, is simple. It's pretty direct, and it ranges from the fact that the proposals on the bill should be properly considered. And we basically propose that the bill, the range of the new surveillance authorizations to be made available to Canadian law enforcement agencies and the Canadian Secret Intelligence Service should be looked into properly to really get to decipher the extent to which this could be, as well as put up proper safeguards that could definitely help in ensuring that this bill is right respecting and it's not such that impacts the rights of Canadians or anyone living in Canada as a whole. This is just an overview of this bill, and I'll hand over back to Tamir to go into more details about the part two of the bill and what it may actually mean in practice.
Thank you, Timilehin, for laying that out. I'm going to actually take a step back and talk a little bit about part one of the bill and then jump into more details on part two. So part one of this legislation, one of the most concerning things that it does is, and this hasn't really received a lot of discussion through the parliamentary debates, of this legislation, which have been a little lacking. But what it does is it paves the way for Canada's adoption of a couple of information sharing agreements that will significantly expand how much information we share with other countries, including our colleagues, our neighbors to the south, which is particularly concerning given the significant the growing divergence between what Canada views as our constitutional imperatives and what the U.S. is willing to do in terms of using its surveillance powers to go after essentially people that are criticizing the government or are not aligned with the government's increasingly regressive view of the world. One example of how this can go awry is there's an ongoing court case going through the U.S. right now where someone who we know is in Canada, but we don't know who they are, basically just criticized the Trump administration on a social media site using an anonymous account. And the US government is trying to force one of the social media company to identify who this person was. And this is deeply concerning. They didn't do anything that's a crime in Canada, at least, right? But the way that the U.S. system, is where it's at right now, this company could be forced to provide that identifying information. And the U.S. has a lot of ways of impacting people who live in Canada if it wants to. So this person, given the way that this played out, the person found out that this request was being put through and was able to challenge it. But in most instances, you wouldn't even know that this request was being made for your information. So you could imagine this information being disclosed to the US government. And then the next time you try to cross the border, suddenly you're facing a level of scrutiny you're not necessarily accustomed to, and maybe even being harassed and maybe even detained just for voicing criticism in a legitimate way that's protected by our constitutional rights in Canada. So it's against this backdrop of like a vastly diverging commitment to human rights between Canada and the US that our government is, with C-22, essentially paving the way to signing this agreement that would significantly expand the amount of information that we're sharing with the US. There's also another agreement that's being, that is being facilitated by part one of Bill C-22 that we'll be able to adopt once the law goes through. And this would obligate us to share information with, again, additional information with the US, as well as with a number of other countries, including countries that have a very aggressive track record of abusing cross-border policing mechanisms to basically go after diaspora communities that criticize their government. So again, this is concerning for us. We would want there to be, very extensive safeguards to prevent this type of misuse if we're going to go down this road. Like, for example, For example, I do actually, there's a question there about Muppets. I do emulate Muppets. So for example, one of the safeguards that we've asked for is to make sure that the law prohibits the government from sharing our information with for investigations of conduct that isn't criminal in Canada at all. This seems like a very reasonable safeguard. Our privacy shouldn't be put at risk for investigations of, things that are legal here and constitutionally protected here, like criticizing a foreign government. But so far, we have not yet had success in getting these types of safeguards in place. So we continue to be concerned with part one of this bill. Part two of this legislation is even more problematic, and we've been calling for the withdrawal of this regime. It would basically let the government, it basically creates a framework that combines vast open-ended powers with very vague and limited safeguards and a highly secretive oversight framework that's shielded from effective judicial scrutiny. The types of orders that the government will be able to put in place include, for example, the government will be able to order companies to keep a significant amount of sensitive information on every single person that uses the service, regardless of whether they're implicated in criminal activity or not. So, and this information could include, now I know, we all know that companies already collect a fair amount of information about us, but there are privacy rules in place that limit their ability to collect some extremely sensitive information, and particularly in situations where they don't have a justification to collect it. And this provision, if it goes through, will let the government override those privacy rules. And the types of things you could see is you might see an order forcing a company like a messaging app to start collecting every single person's location, like where they were at any given point in time for up to 6 months. And then the government will still need a court order to access this information, but what you're creating is a highly sensitive and wide-ranging collection of data, information that police would not otherwise have access to. And you're also not putting any restrictions on how this could be used. So the company could then use this information that it wasn't able to collect before to, to profile Canadians and to use it for its own commercial purposes. And then we're also not preventing, foreign governments will also be able to access this data in their investigations, including for, again, reasons, investigations of conduct that isn't even criminal in Canada. And then finally, we know from experience that these types of wide-ranging data troves are essentially a gold mine target for malicious actors who will try to access this, who will be aware that this information is there and try to access it in order for malicious purposes. So this is a very intrusive capability that could be imposed through this law. The law also provides the government with a very open-ended power that essentially would let the government order any company to create new surveillance tools and capabilities and embed them in their services. This is a framework that is kind of very broad by definition. So by design. So the objective of what the government really wants the ability to force any current or future digital entity to do anything that the government feels it needs to facilitate legitimate surveillance activities. And when you're dealing with something this open-ended, it's very difficult to constrain it in a way that is to make sure that it's going to be applied in a proportionate manner and not abused. So the types of things that this could include today, and this is something that's going to evolve over time as we get new tools and new surveillance objectives, but even today, it could involve one of the proposals for this type of law for the use of this type of law has involved a proposal to force providers to basically install an AI spy tool on every single person's phone that would be able to access information on their device and pull it out and just give it directly to police if they feel they need it. It could include forcing the TV or virtual assistant in your living room to ensure police can activate the microphone or even the camera on these devices secretly, and more. So police would still need a court order to make use of these capabilities, but the capabilities are highly intrusive in and of themselves. And this level of intrusive capability is particularly concerning in light of the democratic backsliding that we are seeing in many places around the world these days, including, again, like fairly closely in our neighbors to the south. And where we see how quickly a government's commitment to human rights can devolve and how quickly it can turn on its own citizens. So the potential for abuse of such powerful capabilities is high, and this law will create a framework for imposing those capabilities. There's also a general concern that forcing these types of digital services to change the way that they operate, to create new surveillance tools, undermines everybody's cybersecurity, in addition to creating intrusive tools for the government. So governments will frequently, and we have a historical record here of various governments, including our own, just being very bad at prioritizing cybersecurity over surveillance when there's a question between the two. And particularly, governments are frequently under the impression that if they create a surveillance tool or build a surveillance capability and embed it in a service, they could do it in a way that they will be the only ones that use it, and nobody else is going to use it. But over and over again, we've seen this presumption to be proven false. We have a recent example of this where a US law that is far, far narrower than the one that's being proposed in Canada was used to force telephone and internet companies to use equipment that would let police intercept phone calls and internet activity through the telecommunication companies' networks. About 2 years ago, a malicious actor associated with the government of China's foreign spying ministry successfully targeted the surveillance mechanism and what's been described by the US government itself as one of the most severe cybersecurity and national security compromises in history. And we've seen examples of this over and over the years. The reality is that once you create a surveillance capability like the one this law is going to require, it's not only the police that are going to make use of them, malicious actors are going to make use of them. And if not properly calibrated, they are going to undermine all of our cybersecurity. Now, typically, when governments propose these types of obligations, they usually do not survive public scrutiny. Occasionally they do, but usually they do not. But a key concern with C-22 in particular is that it will allow the government to impose these requirements in secret. And we have seen how this secrecy will heightens the risk that this type of mechanism will go awry. So the UK has a version of this law, and it is narrower, but it's broader than the US one, but more on par with what's being proposed here. And just last year, this law was used to issue a secret order to Apple. The secret order resulted in Apple removing a critical security safeguard for iCloud backups for everybody in the UK. Now, iCloud backups basically back up everything on your phone. So there's highly sensitive information on there. There's details of your daily lives, who you interacted with, what you said to them, where you were at any given point in time, all your emails, everything. So it's really critical that this information is secured to the maximum extent possible. But now this is providing that security is effectively illegal for Apple to do in the UK for its UK customers. Whereas, this is a safeguard that we in Canada still have available, and other jurisdictions still have available. But in the UK, it's illegal for them to provide that level of security. The constitutionality of this order in the UK is now being challenged, as well as the law itself, by two civil society groups in the wake of this order. But the challenge is only moving forward because the secret order was leaked, and this was done in violation of the UK law's confidentiality requirements. And this in itself is concerning. There's no justification for an order like that advancing in secrecy other than to avoid public scrutiny. So this order should never have come forward secretly in the first place. The government should have just, told the public what it wanted to do, and then allowed for this framework for a public discussion around it, as well as opportunities for groups like CCLA in the UK, our counterparts in the UK, to challenge the order if they felt it was unconstitutional. But the secrecy mechanisms in this law allowed the government to do it in utter secrecy, and only because it leaked in violation of the law do we have this constitutional challenge moving forward. And this is the framework that our government is bringing to Canada, and we're deeply concerned about it. We don't think it's a good framework, and we think it will result in undermining the privacy and cybersecurity of everyone. Now, the government has attempted to minimize how intrusive this law might be when presenting it to the public. So our advocacy around this proposal has been, so we've worked through a broad-ranging coalition with many groups to call out the potential hazards of this legislative framework. We've gone to great lengths to document how these types of powers have been severely misused in the past, so that it's difficult for the government to deny that that there is a severe intrusive potential for how this law might be used. And we've also participated in the legislative process to make sure that the members of parliament studying this legislation are aware of the challenges and the threats that this law poses. And we were successful in getting some minor improvements to the law as it made its way through the House of Commons. The law is still severely problematic, though, as it stands, and we will continue to advance our advocacy as the law moves through the Senate, which is the next step for this law. Unfortunately, we do have a majority government, so at the end of the day, the government is able to force even poorly thought out legislation proposals into law. And if that happens with this law, we will do what we can through the legislative process to mitigate the harms that this law will cause. But if it does become law, we are already exploring different ways that we will try to challenge the law in court. And we'll be looking to that. And that will be the next step in our advocacy on this legislative proposal. I'm going to briefly mention two other legislative proposals that are relatively new and that we've started doing some advocacy around. One is Bill C-36, which is a major overhaul to our federal privacy laws that apply to private companies. So this is updating a law that, I guess modifying a law that's been in place for a couple of decades now in Canada. And the proposal here is one that's been advanced before with some modifications. And it's a recent proposal, so we're still examining its implications and ramping up our advocacy around it. But at a high level, we have some concerns with how this proposal has been advanced, and we will be rigorously calling for more privacy safeguards in this rule. We're particularly concerned that a lot of the benefits that the government has presented in presenting this law, a lot of the benefits that the government is saying this law is providing are things that the existing law already does. And in fact, the legislative amendments, if anything, undermine the ability of this law to achieve those objectives. In particular, the law has a very wide-ranging exception to one of its core safeguards, which is the requirement to get consent from people before collecting, using, and disclosing their information, including their sensitive information. It will let companies basically amass and use personal information to an even greater degree than they currently do without having to get any form of consent. So we're concerned about that. We're also concerned that it's going to require, in its implementation, it's going to require whoever applies this law to consider, to basically take into core consideration anything that we've put into a trade agreement. And this is a concern. This is not the normal practice for how trade agreements are implemented into legislation. And it's a particularly concerning addition, given that we know that we are about to embark on negotiations of NAFTA or CUSMA or whatever you want to call it with the United States, and that the United States framework for private sector privacy is much more permissive than ours. So we're worried that if privacy exemptions are forced into these trade negotiations, they will then kind of automatically feed right into our privacy laws without going through a legislative process the way you normally would have to do. Those are some of our concerns on that. And we're also working with my colleague Anais Boussier-McNichols who directs the CCLA's fundamental freedom programs on another legislative proposal that's looking to address a suite of online harms by imposing various regulations on social media sites and other types of online services. We're particularly concerned with an element of this that relates to, it's presented as imposing a social media ban on people under the age of 16. But we're concerned that the way that these social media bans are implemented tends to undermine the right to privacy fairly significantly, while not actually functioning very effectively. So, for example, Australia has had a social media ban of this nature in place for for a while now, but 70% of people captured by the ban continue to have social media accounts. Not only that, they're now using fake adult accounts essentially, and part of the and this means that they're actually not benefiting. So the way the law currently operates in Canada is accounts that are associated with people under the age of 16 or minors benefit from a suite of additional protections that adult accounts do not benefit from. But if the result of adopting a social media ban is that or most children under the age of 16 still find their way onto social media sites, but then now are using adult accounts, they're actually being exposed to even more risk because they're losing the safeguards that we had in place for minor accounts on the one hand. And on the other hand, they're going to find it more challenging to get help when they face problems on social media because they won't be able to turn to their teacher because what they're doing is effectively illegal. They won't be able to turn to their parent because unless their parents signed off on them doing this in violation of this ban. So we're worried that this ban is going to be counterproductive. We would prefer instead to work on requiring companies to adopt a whole range of additional safeguards to better protect children in social media contexts. There's also a concern as well that social media does remain a critical tool for particularly members of marginalized communities to get information and sometimes a sense of community, like members of the LGBTQ community. Sometimes social media is the only avenue of community and information that they have, when they're unable to get that type of interaction from their family or from their teachers. So that's an additional concern. Instead, what we'd like to see is, just a more kind of direct approach that forces companies to improve the way their services interact with minors, and to provide protections that mitigate the worst harms that we know youth are facing on social media sites. Okay, so that's a little bit of a preview of what we'll be working on moving forward. Both these last laws were just tabled in the last couple of weeks, so we're still in the early stages of our advocacy on them. But yes, that's, I think, with that in mind, I think I will hand it over to the question and answer segment. Thank you so much for listening to us, coming to listen to us, and to Rosemary and Michael for organizing this event. And thank you for your support of the Canadian Civil Liberties Association.
Thank you, Tamir and Timilehin. So yes, so I'm going to pass it over to my colleague Rosemary for the questions in a minute shortly. I just want to remind you, in case you came in later, that we do have the Q&A section. So you won't be able to speak for your questions, but if you want to type in your questions in the Q&A section, we'll try and get to as many as possible. So I have the first question here, and I'm just going to pass it over to Rosemary to ask the first question.
Sure. Okay. Thank you very much, Michael. And thanks everybody for coming today for this really interesting webinar about very, very current topics and our freedoms. So one of the questions from the audience is, what sort of oversight does CCLA want for the election information?
Yeah, so I can answer that. So I mean, this in other jurisdictions, political parties are subject to the same privacy laws as everybody else, with maybe some modification. Like there are some situations where a political party should be able to maybe collect some information without your consent so that it could talk to the electorate. But those are very that like in light of the direction that data-driven campaigning is going, that is maybe a fraction of the type of data usage that political parties are making. So you can easily carve out an exception for that type of practice, while making sure that more generally, when political parties are buying, very, very detailed records on every single person in Canada from a company, a data broker that has 15,000 data points on every single profile that it's selling them, or are using, social media sites to target communications to people. In those instances, we think they should be subject to the same privacy rules as everybody else. Again, maybe with some modifications for the context that they're operating in. And then specifically, we really need to let the privacy commissioners be able to investigate their data practices. This came out, Timilehin mentioned the voter data breach in Alberta, which impacted which revealed voter roll information of close to 3 million people in Alberta. Part of the challenge here is like that a repository of voter information was given to a political party, and then somehow it ended up in the hands of a non-political party, and then it was released to the public on its website as part of its campaigning around a referendum issue. And this is not a good dynamic because the privacy commissioner is only able to look at the non-political party. The Elections Alberta, and they have a similar system in Alberta. Elections Alberta is only able to look at the political party, and there's no ability to really look at the entirety of the interaction to find out what happened, what went wrong, and what needs to improve. It's just a very bad model. So in other jurisdictions, such as in Europe, political parties are generally subject to the same privacy laws as everybody else. It's the same in British Columbia. British Columbia political parties have been campaigning for decades while still complying with privacy rules. So yeah, we basically just want the privacy rules to apply to political parties. We don't think we think it's a really important development that we need.
Okay, thank you, Tamir. The next question is, Bill C-36 recognizes privacy and personal information as a fundamental right, but it still appears mainly focused on private sector commercial activity. Does CCLA see a gap where personal information is collected or disclosed through cooperation between government actors and private commercial entities, such as media, technology vendors, or contractors? Should the bill more clearly address situations where state power enables private sector exploitation of personal information?
Yeah, that's a great question. We do think that the existing and the new privacy law both create a general framework for when private companies are sharing information with the government, but they don't really impose any safeguards, and they actually impede the ability to scrutinize how that information sharing is happening. CCLA actually, we will be advocating for the addition of some safeguards, like particularly transparency reporting and the ability to scrutinize how some of those interactions are happening in the C-36 amendments. But we also have separately a constitutional challenge of the existing law going through the courts. It's currently at the Ontario Court of Appeal, where we're saying that this framework for information sharing that's created by our privacy law is unconstitutional, and calling on the courts to require additional safeguards as well. So we're doing these two things in parallel.
Okay, thank you. Third question, are there circumstances in which individuals can challenge surveillance activities or seek independent review?
Yes. So the courts are there for you to challenge any surveillance that impacts you directly, and you have a constitutional right to privacy that lets you do that. There's also various privacy commissioners that have laws that they can apply to police, and they are able to hear complaints and assess them. The big challenge here is that so in most cases, if you're the subject of surveillance and police find criminal activity, they're going to charge you in court, and you'll know that you were surveyed. But if they don't find anything, you're never going to find out. And other than like in a few isolated instances in our law, we have no mechanism for requiring police to be transparent and to let people know when they were the subject of surveillance and then ruled out as any sort of suspect. And this is problematic. It's in light with it's out of touch with the international human rights framework for surveillance. And it's a really problematic feature of our transparency mechanism of our framework for overseeing police, where all the instances where people are being surveyed, in a way that isn't really justified because it doesn't lead to some sort of criminal charge. Those never those rarely come before the courts and are really difficult to document in a way that would let you do a court challenge. So there are avenues for this, yes, but they're often very difficult to employ, is the bottom line.
Okay, thank you, Tamir. The next question is for part 2 of C22. What is the difference between when a government actor does and does not need a court order to do something it is allowed to do under that framework? And the next part is this different depending on the government actor in question, whether it's the federal government versus the police versus an intelligence agency?
So part 2, C22 is a little bit, it's tricky. So what it can do is dramatically change the type of, so normally police, this is largely, we're talking here about police and CSIS in terms of investigative activities that are being facilitated through part 2 of C22. And what part 2 of C22 does is it really dramatically changes how much information police will be able, or CSIS will be able to get when they use the powers that they already have. And it kind of falls into a bit of a gray zone here because there's no, the government, it's the public safety minister or the government council is going to be able to impose these requirements through a new sort of process that is very, very far from, meaningful judicial scrutiny in the courts, which is where the vast amount of police and CSIS activity is usually scrutinized. So sorry, I don't know if that answers the question, but it creates a really challenging. So CSIS and police have different powers that they rely on when they're conducting surveillance, and these are generally subject to court approval. But C22, part 2 of it, has no judicial authorization at all, and some of the things that you can force companies to do through C22 are more intrusive than anything that police can currently do, or CSIS can currently do for that matter. So this is why we think it's a concerning development and using the wrong framework. Like it should be going through the court authorization process, just like everything else that we rely on.
Okay, thank you. The next question is from a participant who says, I have a surprisingly hard time convincing people that online privacy is important. Apart from financial information, how do you articulate why privacy is important?
Yeah, I mean, that's a good question. And it's one that we run into a lot. I think, for us, we've seen many examples where, doing this work where, people who themselves have never done anything wrong and are just going about their lives get implicated in some sort of investigation because of the way that their information is used to draw inferences about them that aren't really reflective of their actual lives. There's a lot of policing often operates on a guilt by association sort of metric. And this is being rapidly accelerated by the adoption of various AI tools into policing that do a lot of work on a lot of these same sort of assumptions and rely on our personal information to draw these assumptions, but are often not accurate. We talked a little bit about facial recognition technologies earlier in the discussion. Again, there's these tools have been around for a few years, but not that long, and there's already many cases of people being falsely arrested based on a false facial recognition match and having to spend time in court, time in jail, and while their case gets sorted out. And we're relying more and more heavily on these tools in ways that could significantly lead to even more severe consequences. I'll just throw one additional example, pre-technology example, on how this can go awry here. Canada, so we have, in the wake of 9/11, there was a really heightened information sharing paradigm between Canada and the US. And this led to one person, a Canadian, Maher Arar, being identified to the FBI by Canadian police as a potential suspect, terrorist, or something like. He was identified as a potential terrorist to the FBI by the RCMP without his knowledge. And this was just based on the fact that he had had coffee with someone whose cousin was somebody else, whose neighbor was on a watch list or something. Maher, very, very regrettably, next time he flew through the U.S., not knowing that he was implicated in all this and not thinking that he'd ever done anything wrong, was renditioned to Syria for 3 years and tortured for 3 years in a Syrian prison by the U.S. government. Eventually, he was returned. The government, he sued the government successfully. The government has apologized for this. Everybody acknowledges he never did anything wrong. But I think we're sadly moving in these times of heightened security concerns that we're starting to move into again. These types of consequences do occur, and even the more day-to-day sort of consequences that can result from these types of associational suspicions can be very, very disruptive to day-to-day life. So I think that's, for us, like, this is why we're concerned about these types of privacy mechanisms. It's not really what you did or what you think your information says about you. It's what somebody else might think your information says about you and how they could use that information against you in a way that doesn't really align with your reality.
Yeah, so I was just going to add that another example, just to augment that has already been given, is imagine a situation whereby isolated searches are being used to draw inferences and decisions about what an individual thinks or feels. Isolated searches in the sense of, just for example, doing a search in line of work, and that is being used to draw inference about who you are, what you think, your ideology, etc. So that's another example that really gets to drive home the point on why privacy is important.
Okay, thank you, Tamir and Timilehin. The next two questions are about Bill C-36. The first one is, what do you see as the pros and cons of C-36 turning over responsibility for private sector privacy matters to a cabinet-appointed regulatory body, as opposed to the OPC, which reports to Parliament?
Yeah, so we're really I don't know that we see many benefits to that shift, and we see it as a negative for a couple of reasons. One is there's a new safety commission that's being developed that will have that it does have some level of independence, but it is something that the government, the commissioners in that body are going to be government appointed rather than appointed by by all the parties, the way that the privacy commissioner, in consultation with all the parties, the way that the privacy commissioner currently is. There's particularly a problematic feature of this new commission where one of these commissioners, there's going to be 5 of them, one of them is going to be responsible for privacy, and this deciding which commissioner is responsible for privacy is something that the government is going to be able to do kind of at its whim, with no safeguards for excuse me, with none of the safeguards for independence that you need to properly do that job in a way that prevents the government from saying, we don't like the way you responded to this particular type of investigation, we're going to make somebody else the privacy commissioner. That's one of our concerns regarding this shift. But more generally, the federal privacy commissioner office right now has immense expertise in dealing with privacy. It's it's like internationally recognized as an expert body that knows how to do this type of work. It's going to continue, and it has oversight over both government privacy and private sector privacy right now. This Bill C-36 is going to take away the private sector component of this while leaving the public sector component of this. So it's kind of a split of expertise that doesn't really make sense to us. The government is saying that a couple of the issues that the new safety commissioner is dealing with, like we talked about the social media ban and age verification mechanisms, a couple of these features do overlap with things that the privacy commissioner is doing, but there's much more overlap between, public sector and private sector privacy. We had a question before about information flowing from private companies to police. Like, you really need a cohesive picture of both the public and the private sector on the privacy side. So we think this split this shift is really going to undermine the ability of the privacy commissioner to robustly kind of champion people's privacy rights in Canada, and we're worried about it.
Okay, thanks, Tamir. This is the second question on Bill C-36. How should Bill C-36 address consent in inherently coercive or unequal power settings? For example, where a person is detained, dependent on officials, seeking access to services, or otherwise not realistically free to refuse. Should consent be presumed invalid unless there are heightened safeguards?
Yeah, and arguably, I mean, we would argue for sure that the existing consent requirements in the privacy laws already would not qualify. Like you wouldn't if you're in a situation where you're essentially coerced to give consent, that wouldn't qualify. This isn't the private sector context, this is the public sector context. But there's an example where a case that a privacy commissioner decided where migrants were essentially being, or people coming into Canada were essentially being, given the opportunity to consent to being included in a video, in a documentary of some sort that CBSA was doing. And again, you're in this situation where like maybe you can say no, but this person basically has a very significant control over your life. It can really make your life miserable if you say no and they're not happy. And the privacy commissioner said in that context, this consent was not valid. You need an additional kind of more heightened mechanism here to allow for people to refuse this type of activity. You also see it under European law in the workplace context. Workers are not in a place to really kind of say no to their employer if their employer is asking them to consent to things. So consent needs to be treated in a more kind of rigorous way in those contexts. So I would say that those principles are already in our law to some degree, but and they should be strengthened. I think that would be a helpful development for C-36. Again, unfortunately, I think C-36 goes in the other way and actually kind of makes it easier to really bypass consent even in those situations as currently drafted.
Okay, thank you, Tamir. This is the last question because we're getting close to time. And it is, do you have allies that you're working with? It's a long list of things you're working on. What kind of allies are you working with?
So yeah, we've been it's been really a gift to be able to work with a wide array of people who are concerned about this. In our work on privacy in the immigration context, we've had the pleasure of working with some of some of the leading migrant rights groups in Canada and refugee rights groups in Canada. We work with labor groups. We work with other digital rights groups. Our work is informed by groups that are dealing with LGBTQ issues like EGAL, and by groups that are much working on Indigenous issues like the Association Assembly for First Nations. Our work is extremely collaborative. We have one slice of the answer to a lot of these problems, and we work with women's rights groups like the Legal Education Action Fund, LEAF, as well as with digital rights groups like Open Media on the West Coast and the Freedom of Information and Privacy Association, who are partners in our voter privacy campaign. My view is that we have sort of one slice of how to address these various privacy challenges and technology challenges that we're looking at. But we don't have the entire picture, so we need to work as part of coalitions to really understand how everything is impacting, different segments of society and different contexts. And we are extremely collaborative in this way. If any of you are in any of these groups and want to collaborate with us, just email me. Thank you.
Okay, thank you. I'm going to pass it back to Michael, and then we're going to wrap up with closing comments. Thanks very
Yes.
much for all these questions.
So thank you again for all the questions, everybody. Unfortunately, there was a lot. Unfortunately, we couldn't get through all of them. If you do have questions, you're always free to email us at info@ccla.org, and we'll try and answer your questions that way. We had a lot of people showing up, a lot of questions, unfortunately. So if we didn't get to your question, we apologize. Timilehin, do you have anything final words to say before we wrap up?
Yeah, I'll just say the privacy issues are definitely not anytime ending soon, and so there definitely needs to be more attention to these issues. Definitely, it's also not just for the CCLA alone to keep pushing those ideas. Individually, also, we definitely should raise the concerns with those in our circles because jointly is the only way we can win the fight.
Yeah, and I just wanted to thank everyone for thank again Rosemary and Michael for hosting this, and thank everyone for the wonderful questions. And yeah, if anything didn't get answered, my email is, I mean, it's on the website. If you don't have it, feel free to contact us, and we'll do our best to respond. Thank you.
Thank you, Timilehin, Tamir, and Rosemary for this. So yes, we're going to end it here. It's 4 o'clock. So just a reminder, this was recorded. We will be sending over the recording within a few days to you. So if you want to watch it again or weren't able to see the whole thing, we do run these quarterly. So we'll be sending out the next one for a different program within a few months. So make sure to sign up to our e-newsletter if you're not already on that. And we'll hopefully see you at the next private or webinar that we run. So thank you everybody for coming. Bye.